The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Back down.
This court of common pleas in and for Butler County, the Honorable Gentleman McGuffrey presiding, is now in session.
Good morning. Back on the record in State versus Madden, CR 22-121675. And Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio. And Mr. Madden appears with counsel, Mr. Wilder. The jurors are not in the room. Before we bring the jury in the room, is there anything that the state would like to put on the record?
Good morning, Your Honor, and hopefully so. Thank you.
Okay, anything on behalf of the defense at this time?
Yes, Judge. This morning, we had a couple witnesses who were going to testify. One of them is Mr. Madden's brother, Tim, who's in the courtroom today. I plan to call him, but it's my understanding that my client does not want that done, so I would want to put that on the record. That
Very
he does
well.
not want that to occur.
All right, very well. Anything else you'd like to put on the record today?
We also had a neighbor, Tamara Dewar. She was here Monday and Thursday. I thought she was going to be back here today to testify. She does not appear to be here at this point. However, given some of the testimony by other neighbors and the reason she was going to be called, I think we have got into evidence, so I'm not requesting that her appearance be found at this time.
All right. We will be letting the state of Ohio rest, and would you like to present a case after the state has rested?
Your Honor, with those things that I just mentioned, the only other potential witness would have been Mr. Madden himself. So I don't know if this is the time to discuss that or not, because his decision whether to testify or not. So given that he doesn't want his brother and there's no other witnesses ready and available, Mr. Madden is the only remaining one. So I think we need that colloquy now.
All right. Mr. Madden, you do have the right to testify in this trial. It is your constitutional right. Do you wish to exercise that right today?
No, ma'am.
All right, then we will let the state rest its case, and we will be prepared for closing arguments. Let's go ahead and take a seat, because I think we're going to have some other business then to take up, so we can move a little bit more smoothly through the process. Okay, so we'll be ready for closing arguments, and we talked about our jury instructions. I did see that you filed a proposed jury instruction. Mr. Wilder, I have reviewed your motion. Is there anything else you'd like to put on the record in support of your request?
No, Judge. Everything I would say right now is contained within my motion. It's filed as record, so I would stand on the motion and incorporate those arguments in the paper as if stated here this morning. So I would stand on my motion.
All right. And does the state wish to respond to the request for the jury instruction?
So, Your Honor, voluntary manslaughter, I read as being defined as no person while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by the victim, that is reasonably sufficient to incite the person into using deadly force, shall knowingly cause the death of another, or the unlawful termination of another's pregnancy. Obviously, that part doesn't apply. Well, I certainly will probably, there'll probably be some arguments that stabbing somebody 55 times certainly seems to be a sudden fit of rage or sudden passion. I do not believe that there's any evidence that would suggest, or any evidence that we heard from this witness stand that says that was brought on by the victim, Rachelle Brewsaugh. So at this point, because that part is lacking, I would object to the instruction.
Okay, well, the court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case, 2021, Ohio 1537. And in that case, the trial court declined to give an instruction on voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011, Ohio 666, in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence that the defendant believes was proffered that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give the voluntary manslaughter instruction, so it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over to the court proposed previously?
I think all of them are standard issued OJI instructions. I would just ask for a new copy of what it is. It's also going to be read to the jury.
Okay. Any other requests or additions, Mr. Wilder?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to the jury.
I do, Senior. Your Honor, when I read through the draft, I
Yes.
think the pronouns were wrong in
Okay,
some of the parts.
okay.
I think it said her, it should say him.
Okay. I will hopefully catch those as I
Okay.
read them and make the changes for the final copy that I'll provide to you and before it goes back to the jury.
Thank you.
jury.
Judge, if I
Yes,
may,
sir.
I did note that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is.
Oh, because we had it in that
It
he
says
would.
defendant
Yes,
does
sir.
testify, so obviously there needs to be language about him not testifying and accepting the standard language of not
Yes, sir.
use that against, so.
All right. Thank you for that.
Your Honor, if I can just add one more thing. I've asked him multiple times to paint us some information that would show how this all started, and he's refused over a period of months. He's told me to my face that he's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rachelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living there. But he thought that wasn't sufficient enough evidence for the jury to hear, and I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand, but listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective, this gentleman right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes, down to the bottom of the basement, inside a cell, you could hear me screaming out, why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, you know, when I said, hey, ask him if he knows Rachelle's niece who works at the front desk at the Hamilton Police Department in the same building that he works at. I just asked him if he how well he knows her. He refused to do that. So there's so many things that I thought that I just wanted to put on the record. And that's all I had to say right now.
Is there anything else, Mr. Wilder?
Judge, I'm not going to respond to the allegations, because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I'm prepared to argue his case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, one other thing. You know that on March the 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45. Times that my family didn't even know that because times weren't being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always, and woken up out of my sleep, said, hey, you got a court date today. Having hearings without me there. But I was in the jury box, and I said, hey, they were wanting to have a proceeding with me while I was inside there. And I said, I protested. I said, hey, listen, I'd like to be at the desk, so that I could go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can surely 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sit at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, he said, get him. And I had the shoes beaten off of me all the way down the hallway, down 2 hallways, down to the elevator, and this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to me.
We've talked about some of this before.
Okay.
Your jury is waiting, and I don't want to keep them waiting, okay?
Yes, ma'am.
So if
Yes, ma'am.
if everybody's prepared to go forward, we'll go on with the closing
Yes, ma'am.
arguments, and I'll have the jury instructions modified while we're doing that and have them passed out to you before they're read to the jurors. But we will
But
change the
I did ask
language
for
of that.
on the record, I did ask for that preservation of that footage. Of the footage when I was beat up at the jail too. So, but none of those things. Multiple. But here we are.
And we're going to go ahead and bring in the jurors. Okay, thank you. Does anyone have any violations of the court's recess instructions to report? Okay. All right, we left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, the state has no other witnesses to present. So, ladies and gentlemen of the jury, the state will rest.
Very well. And Mr. Wilder, does the defendant wish to present a case?
No, Your Honor, thank you.
Very well. Okay, so ladies and gentlemen, you have now heard all of the witnesses, and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words in a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.
We move the...
Sure.
Thank you. That's fine. All right.
Yes, sir. What do you have numbers you want? Because it's the
I'll know, but you use the computer first. Do I need to push this? Thank you. May I proceed?
You may.
Morning, ladies and gentlemen. Echo there. I'm going to read to you Toby Madden's own words. These are the words that he spoke on Monday before you entered the courtroom, before opening statements. I'm responsible for what happened to her. I didn't mean it. I'm so sorry. I love you. Please don't hate me. Can you put up State's Exhibit 181, please? This is what he's responsible for. Can you put up State's Exhibit 40? This is the it that he didn't mean to do. 55 times he didn't mean it. Let me take that down. If you recall from my opening statement on Monday morning, I told you how every trial is like a puzzle, and that you receive pieces of the puzzle throughout the week. And that's what's happened this week. And you received those pieces of the puzzle from the exhibits that have been admitted and from the witnesses that have testified. And I want to talk about those pieces that you've received all week long. I want to help put them together for you. So we know, and I'm not going to go in the same order that they came in, but I'm going to try and put this in chronological order for you. So we know from Michaela Madden and Tanya Cook that the defendant and Rachelle were together for about 25 years, or north of 25 years. That they moved around from place to place. Michaela said they moved around from place to place, and they finally moved to 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio, in the early of October of 2022, and that they were renovating this home and fixing it up to live there. We also know from Michaela that they had a rocky and on-again, off-again relationship. And we know from Tanya that the defendant had been seen hitting Rachelle in the past, and that he said that he wanted to cut her head off and put her in her mom's lap. And he said it multiple times. I'm not sure that rocky is the right word for that relationship. We also know from Detective Horton that on October 10th of 2022, the defendant went to the Kroger on Route 4 and Grand Boulevard here in the city of Hamilton. And that was in the evening. And you saw the video and the still photos. He had on a gray shirt, short sleeve shirt, button-down shirt, a green vest, white shorts, and Nike Kevin Durant 8 shoes, or KD8s. And that was in the late evening around, I believe it was around 8 p.m. on October 10th. The next pieces that you got were from the City of Hamilton utility workers. You heard from the 4 of them, specifically the 3 that went into the house. We know that there was an appointment that they had at 8 a.m. on October 11th in the morning, that they showed up on time, that Rachelle let them in, and that she sat on the couch, had a hold of their large, big dog. I believe one of them said it looked like a pit bull. All the furniture was in its place. The china cabinet was upright. The entertainment center was upright. There weren't any chairs overturned. Nothing was overturned. And that they walked through the house and they saw a male sleeping in a chair in the adjacent room. They went into the basement. They did whatever it is they were doing, running their test on the gas line, and they determined that they can't turn on the gas because the furnace is broke or it hasn't been fixed yet. And they go back upstairs, and they're leaving at about 8:25. They see the male still in the chair. I think he acknowledges a "what's up" to one of them. They tell Rachelle that they can't hook up the gas because the furnace isn't working. And that one utility worker told you that she then looks to her right to the adjacent room and gives a stare or a look to the male in the chair. And that when they left there around 8:25 in the morning, she was alive, she was well, still had a hold of her dog, everything was fine in that house. And we know from Ann Mayers, who testified, that, as she did every day, as she said, she was on her porch at around 8:45 a.m. because she watches her sister's grandson with her sister walk to school at Crawford Woods Elementary, which is right down the street. After the grandson gets around the corner and heads up to the school and out of eyesight, her sister goes inside because she said her sister wasn't feeling well. So Ann sat out there, still drinking her coffee, looking at her phone. And she tells you that sometime between 9 a.m. and 10 a.m., roughly, she doesn't remember exactly, it was 2 years ago, that she hears a scream. You all heard it. She did it for you right here in the courtroom. And she said it lasted 5 to 7 seconds, and then it came from her left. And she's at 1260 Parrish Avenue. They're at 1270 Parrish Avenue on her left. But as she said, she doesn't know. There's a lot of kids in the neighborhood. There's a lot of screaming that goes on, but she heard this one from that direction, but she didn't do anything about it. She didn't call the police. Said she went inside and she ate breakfast. And from that time that she was out on her porch, she said there was no one else out there at 1270. She didn't see anyone. The utility workers had already left. And then the next thing we know is that Officer Katie Johnson arrives there around noon or 12:10 in response to a 911 call. She gets there. The defendant's inside giving CPR to a clearly deceased body. There's multiple stab wounds in the body Officer Johnson saw that. She said the body was very pale and the intestines were protruding from the torso. She pulls the defendant off of Rachelle and takes him outside. At this point, he's got on a lime green shirt, shorts, and Reebok shoes. Officer Johnson told you at that time there is no signs of forced entry in that house. So when you look at the timing from when Ms. Mayers told you that she heard that scream, and by the time Officer Johnson gets there, the defendant had roughly 2 hours to be alone in that house with Rachelle. And you heard from numerous detectives about the scene and their investigation and the pieces of the puzzle that they give you. When they get there, there's no forced entry. Front door jamb is fine. The back door, it does have a dent in the door, but it's got 2 deadbolts. You saw the picture of that. That door's locked. It's secure. Rachelle's lying dead in that front room with multiple stab wounds in her body. That front room is in disarray. Furniture's overturned. You saw the cabinet on the floor right next to her. There's blood everywhere, on the walls, on the floor. It smells like rubbing alcohol, and there's 2 empty bottles of rubbing alcohol in that room near her. And then in the basement, which is completely dark, if you remember, those detectives told you, there's no electricity down there. They had to light that up themselves. They find the green vest, a bloody green vest. Turns out there's the bloody gray shirt down there, which, yes, they didn't get that until about 15 days later because of the Kroger video. But they don't find any white shorts or any Nike KD8s. There's a wooden board on the ground next to Rachelle's body with 2 distinct shoe prints on it. One of which is that Reebok shoes that he was wearing when the police got there. And the other one, this Detective Horton told you, as he found on the internet, is a shoe print of a Nike KD8. There's blood in the bathroom sink and on the bathroom floor. And keep in mind, he had roughly 2 hours from the time Ann heard that scream to when the police got there. They find a Swiss Army knife in Rachelle's bag. And it appears to be wet when Detective Horton finds it. Detective Trenham tells you when he examines it, it appears to be rinsed or washed. And it's got a deformed blade, a broken blade, that matches and is similar to the tears in the fabric in the green vest and the cuts in that Planet Fitness shirt that Rachelle was wearing. And you know from Detective Horton that the defendant told him, you got to find those 3 city guys. You got to find them. There's people out to get me, but there's not anybody that I know that wants to hurt Rachelle. And then Catherine Daly from BCI supplies you with these pieces. Rachelle's blood is on Toby Madden's green vest. Rachelle's blood is on Toby Madden's gray shirt. Rachelle's blood is in that bathroom sink. And Rachelle's DNA is down in the well of that Swiss Army knife. down in a part where, as she said, you're not going to stick your finger down in there. It's not going to fit. And we know from Dr. Updegrove that Rachelle died from 55 stab wounds. They were on her arms, they were on her leg, they were on her torso, they were on her head, and one in the back. And he told you that there were defensive wounds on her hands and her arms, the bruising on her hands. He also told you there was a small knife that was used. And he told you that when you look at those pictures, the darker wounds are because the blood was still pumping. Her heart was still pumping. And those lighter wounds, they came as the life was slipping away out of her. You put these pieces together, and I submit to you that this is what you get. You got 3 City of Hamilton utility workers that leave that house and everything is fine. Something happens at this point. It's a piece we don't have because the only 2 in that house are the defendant and Rachelle. Maybe she says something to him about the furnace. We don't know. But he goes off. And ladies and gentlemen, there's 1 stab wound in the back. And I submit to you that that's the first one. He attacks her from behind. He stabs her in the back with a Swiss Army knife. She turns and she tries to defend herself. And this is where the defensive wounds come in. And he keeps stabbing her over and over and over 55 times. And in this process, they're knocking over the furniture. She's trying to get away from him. She's trying to live. She's trying to survive. But she doesn't. And then he changes his clothes. He throws that vest and that gray shirt in a completely dark basement, hoping that no one will find it. He ditches those white shorts and those KD8 shoes. Don't know where. Can't find them. He had 2 hours to do it. Then he tries to clean up. He's putting that rubbing alcohol everywhere in that front room. Detective Huckey told you, distinct smell. Then he goes in the bathroom and tries to clean himself up. That blood's everywhere in the sink. Her blood that he's washing off of him, washing off of his own hands, washing off of his own arms. And then he tries to clean up that knife. He tries to get her blood off of that knife. And then after he does all of that, he has the audacity to start giving her CPR when the police arrive and try to blame it on 3 City of Hamilton utility workers. And the final piece of that puzzle is what the defendant gave you here on Monday morning that I've already told you. I'm responsible for what happened to her. He said it to his daughter, sitting in the back of the courtroom. Ladies and gentlemen, you're going to have 4 counts here to consider when you go back to deliberate. And the judge is going to instruct you on the law and what some of the terms are in those counts and what they're defined as. And I'm going to give you a shorter version of that here now. Can you turn it? Thank you. So I'm going to take these in reverse order. So I'm going to start with count 4 because I think it's a more logical way to look at these. Oh gosh, how do I, I'm sorry, do it one second. I think I got it. Count 4, felonious assault. Knowingly cause or attempt to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon, in this case a knife, and then it occurred on October 11th, 2022 in the city of Hamilton, Butler County, Ohio. The judge is going to instruct you that knowingly means a person acts knowingly regardless of their purpose when the person is aware that their conduct will probably cause a certain result or probably be of a certain nature. When you stab somebody 55 times, it's pretty clear that that conduct is probably going to have a certain result or be of a certain nature. I don't think there's any disputing that. And in this case, he used a knife. I submit to you, it's that Swiss Army knife. And clearly, as we've stated over and over, and you've heard, this happened on October 11th, 2022 at 1270 Parish, the city of Hamilton, Butler County, Ohio. Count 3, felonious assault again, serious physical harm. I just read to you before what knowingly means. It's the same argument. Cause serious physical harm to Rachelle Brewsaugh. Ladies and gentlemen, there is nothing more serious than death. That is the worst kind of serious physical harm. And again, October 11th, 2022. Count 2, murder. Caused the death of Rachelle Brewsaugh as a proximate result of committing the offense of felonious assault. We just went through those felonious assault counts. 55 stabs. She's killed. She's laying dead in that floor in the front room of 1270 Parish. Count 1, murder. Purposely caused the death of Rachelle Brewsaugh, again on October 11th of 2022. The judge is going to tell you that a person acts purposely when it's his specific intention to cause a certain result. Ladies and gentlemen, there is no other result that can be intended from stabbing someone 55 times. There's no mistaking that. Clearly it killed her. It hit her internal organs. It hit her liver. Pierced her heart. Pierced her lungs. That's a certain result. You know what you're doing. So you've sat here a week and listened to all of this. You've received all the pieces of that puzzle. You put them together. It's very clear. That puzzle is the defendant, Toby Madden. Find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder?
Thank you. The first thing I want to do is thank you. We've taken 5 days away from you. Some of you may be happy that you're away from work, but we've taken you away for 5 days to consider this case. And as we can all agree, couldn't get much more serious with allegations than what we've been here all week for. Don't think that it doesn't go unnoticed that we don't see you paying attention listening to the witnesses. Didn't appear that anyone fell asleep. We appreciate that you did that because a serious case involves serious jurors, and you were up to the task. Before I start with making my comments and arguments about the evidence, when you caused the death of someone, the state of Ohio has to determine, well, what's your level of culpability, meaning something, was it negligent, was it reckless, was it intentional, was it purpose? For example, you run a stop sign driving and you hit a pedestrian and they die. Something like that could be negligent. You're coming here to court today, you're going down the interstate 110 miles an hour, and you hit a car and somebody dies. Well, you didn't mean for that to happen, but you were certainly probably reckless. You also may have a situation where you get in a car, you see somebody, and you tell yourself, I'm going to hit that person. I'm going to run them over. Then you start to get into an intentional, purposeful act. And then the top of the top, which is not here, but you decide, I know when, where somebody's going to be, I'm going to hunt them down, and I want them to die. And that gets into something much more higher than what we're here today for. My point with this is you can't just focus on the fact that someone is dead. You have to look at their level of culpability, because this level of culpability is in these elements. The judge will give you the instructions on this to make that determination. Toby and Rachelle, they're together 28 years. Some of you jurors may not even be 28 years old, or just a little over than that. That's how long they were together. They're together Michaela's entire life. They're both grandparents together. Their relationship, you heard from witnesses, it's up, it's down, it's hot, it's cold, it's rocky. We even heard about some physical confrontations. Not every relationship is perfect, and certainly this one was not either. You also heard evidence that Toby believed that Rachelle was cheating on him. You also know that Rachelle is trying to renovate the parish. We saw the pictures, you saw the materials, you heard from witnesses. She's trying to get what used to be apparently a drug house, people in and out. They're trying to get this together. They're trying to renovate it. And it's not something where she's doing it and she continually kicks Toby out. Toby's there almost every day. You heard evidence, you heard testimony that Toby may be involved on some level with helping this. He's there when she's trying to get the gas fixed. So I submit to you that they're both renovating this parish avenue. Maybe to start a different life, the new turn in the relationship, the hot and the cold, maybe now we're hitting our stride, we're back to good. Let's go to parish and get this thing together and turn a corner. The neighbors are happy to see them. I know Miss Myers, the bank robber, she comes in, she's Toby's strange, he's a little weird, but he's over there every day. She lets him come into her house, use her phone. She's thrilled to have Rachelle and Toby there because she told you what kind of people were coming in and out of that house. Finally, she has good neighbors. And when she says neighbors, she's referring to Toby and Rachelle. Back to the culpability. All right, so Toby is charged with two different types of murder. In Ohio, there's two different statutes. The first statute that you can be charged with murder is under Section A. In order to prove that, the state has to prove beyond a reasonable doubt that Mr. Madden purposefully did this. More specifically, that Toby's specific intention was to cause the death of Rachelle. That this is what he wanted. That was his specific intention. Rachelle needs to die. The second way to prove murder in Ohio, the state is charging him in a knowingly manner. It's called felony murder. And as a result of that, you have to prove the culpability. We call it the mens rea, what someone's thinking. They have to prove that he knowingly wanted it to happen. For knowingly, state has to prove beyond a reasonable doubt that Toby was aware of his conduct will probably cause a certain result or will probably be of a certain nature. That he knows what he's doing. That she needs to die. I want her to die. I'm going to do this so she's dead. Part of count 2 involves a deadly weapon. We're going to get back to that in a second. But these, I'm assuming the Swiss Army knife, the 2-3-inch tiny Swiss Army knife, I'm assuming that's what they're alleging as the murder weapon, the one with no blood on it. We'll come back to that. So, we have these two things. We have purpose, and we have knowing. Let's think about the evidence here. You didn't hear from Toby, but the state decided to not only play, but talk about what he said here in open court. Nothing could make an attorney more nervous than when a client starts to talk, right? This is what Mr. Madden said. The state has put this into evidence. I'm responsible for what happened to her. I didn't mean to do it. I'm so sorry. I love you. I don't want you to hate me. I don't think any witness, law enforcement, neighbor, whoever, didn't deny. Also, Toby was hysterical. He's distraught. He's crying. He can't keep it together. The detective said he was down there for 4 or 5 hours. And he didn't see the video, but he did agree with me. Mr. Madden spends almost all that time just laying on the floor, hysterical. He's given CPR to Rachelle. State even wants you to think that he's given her CPR after she's even dead. Is it someone who purposely wants someone dead? Why would you even give CPR at the beginning if you've done it? And why would you continue? If she's dead, that's what you want. You leave them alone. You walk out. You get Rachelle's car out front and leave. You walk away. You run from the police. You don't sit there and continue to give CPR to someone who's dead if that's what you want. What's the point? We're going to get to that. What about the gas service guys? Hey, we come in 8, 9 o'clock, whatever time. Rachelle's got the big dog. We're there to do a job. Nothing seems unusual to us. Rachelle doesn't seem worried, upset, afraid. Heck, it sounds like Toby's asleep in the chair. No worry in the world. Is right there in the chair, maybe woke up and said, "What's up?" We don't hear from them gas workers there's any tension. I mean, I know they're not there to be Dr. Phil or somebody like that, but think about it. If you're a serviceman going in and out of people's houses, you see something wrong, you may walk out and think, something weird about that. You know, I'm here to do the gas, but in your mind, you would remember that. Because they certainly remember the dog, right? The big dog, 2 years, they still remember that. If they just saw something unusual, they would have told us. Here's my point with that. Got Toby asleep, everything calm. Then, 2, 3 hours later, if the state would please pull up 39. Just so you know, only one computer's connected, so that's sometimes me. 2, 3 hours later, here's what we got. The gas guys went in there and said nothing wrong, didn't see anything wrong. She seemed fine, he was asleep. I didn't see anything on the floor. Police come in, here's what they see. Also, please pull up 40. They see Rachelle there, broken lamp, furniture on the floor. What do they also find? Please pull up 64. Blood on the windowsill. 67, please. Blood splatter on the wall. So we go from gas workers saying, no problems, everything seemed fine. 2 hours later, we got this. So what happened? Well, what about motive? Why would he want her dead? The state doesn't have to prove motive. They'll get up here in a minute and probably tell you that. You'll be instructed that they don't have to prove motive. It's a good thing they don't have to prove it, because guess what? What is the motive? Where is it? What did we hear? Why would he want to stab her? I mean, these people are together this long, and if you believe Miss Cook's story, that Toby Madden continually said he was going to cut her head off and put her head in the lap of grandma, similar to something out of The Godfather. Well, if you do, I'll just say whatever. Why is that happening? Where's his motive to want to do that? Everything is fine, not even 2 hours before. They're working together on this house, 28 years together. They got grandkids. And remember, we go back to the mental culpability. It's not that she's dead. It's not that her death is caused. It's the mindset. Right? Because in this scenario where I run a stop sign and I run someone over and kill them, that's a homicide. Someone's dead. But then when I get in my car and I go, I know where you're going to be. You're going to be at Starbucks at 9 o'clock. I'm going to hunch down, find you, run you over. Those are both homicides. Those are both scenarios where someone is dead. I've caused the death in both of those. The problem for the state is that you've charged him with the highest level, that this is what he wanted, that Toby Madden wanted her dead. If he's continually, again, if you believe Miss Cook, that he walks around saying, I'm going to cut her head off, put it in mom's lap, wouldn't something have happened before 28 years? I mean, why that day? Because something happened in those few hours after those gas workers left. Something quick happened. There had to be an argument, something, because all that furniture's on the ground. Now, I am not bringing up Toby's injuries that we're going to see here in any way to try to say that he's a victim. I'm not. If the state would please pull up 82.
I am in no way trying to compare and contrast some of these, what appear to be maybe minor injuries on Toby that the police took. I am not trying to do that in any way. It is terrible what happened to her. But does this tell us a story about something that may have happened? Because the state wants you to believe Toby, after 28 years, renovating, we're grandparents together, October 11th is the day Rachelle needs to die. Something happened. Furniture, Toby's injuries, while minor, something's going on. We know he thinks she's cheating. Right? People told us that. His own daughter told us that. He thought she was cheating. It's hard to imagine that October 11th was the day that Toby just decided Rachelle needs to be done. And I know I've harped on it twice, and I'll harp on it a third time. Because don't just look at the fact that there was a death caused. You have to look at the mental element. Because the state has to prove beyond a reasonable doubt every element. They have to prove that her death was caused. Absolutely. They also have to prove his mindset. Did he act with purpose? Did he know what he was doing was going to cause her death? If the state could please pull up 149. I believe that the state's claiming that this is the murder weapon. I bet there was another knife, but it wasn't even analyzed. I mean, Toby, you didn't hear any evidence that he left or anybody else coming in or out, so this is the knife they got. And if this is first of all, I submit to you, this is not a deadly weapon, because I don't know if it could inflict the injuries that some of those are. You had officers there for over 9 hours, and they went there for 2 days. And this is it. This is the deadly weapon. But it doesn't have any blood on it. It was sent for analysis. Nothing there. I mean, if you're going to stab someone 55 times to the point where intestines are coming out, and it's deep enough to touch the heart. I know I started with the liver, and then the coroner said, well, you can get to the liver like this. But then he said something like the heart is a little different. State has to prove to you that he used a deadly weapon. This is what you've been provided. I submit to you that wasn't even used because there's no evidence that it was. Or DNA or what it is. The DNA expert talked about something being down inside this Swiss Army knife, but it wasn't blood. 55 times, intestines out, and there ain't any blood on that? You got one detective who said, I went in, it was so unbearable, the smell of alcohol. Next officer said, no, I didn't smell anything at all. Did you hear any testimony that, hey, we went and got Toby from the scene, we were interviewing him, and he smelled of alcohol. Rubbing alcohol, not like liquor, booze. Who else told you that? Nobody. If you're cleaning up the crime scene, as they've claimed, where is all the evidence of this alcohol and stuff? It's not there. And you know what that also does? It proves that he didn't purposely do this, that it wasn't his specific intention. He didn't know that's the result. People who clean up crime scenes, people who leave them, do that stuff. Those are the people who want something done, and they're going to take care of it after. People who want others dead don't stick around to give CPR, and don't give it to the point where someone is dead. Ladies and gentlemen, the state of Ohio can't meet these elements. You have to stay focused on the mental element of this. She's dead. It's horrific. It should not have happened, but it did. The element you need to focus on is the mental part of this, because they want to prove to you, and they have to prove to you, that this is what he wanted. And that's simply not the case. Thank you.
Thank you, Mr. Wilder. State rebuttal?
Yes, Your Honor, thank you. May it please this honorable court. Good morning, ladies and gentlemen. 55 stab wounds. 55 stab wounds. To the head, the arms, the hands, chest, abdomen, liver, lungs, heart. 55 stab wounds. Ladies and gentlemen, this is personal. This is personal. And again, we heard there was some cross-examination about when they're break-in, 5 days prior. This isn't some druggie coming in and doing this. This is a personal attack that happened. 55 stab wounds. Nobody else came in and did this. It was this defendant right there. Now, the city workers, they had nothing to do with this. It was this defendant. And I submit to you, ladies and gentlemen, this defendant committed purposeful conduct and knowing conduct. And why is that? What do we learn from Catherine Daly from BCI? She told you that this defendant's clothing, the vest that we saw him wearing at Kroger, the gray shirt we saw him wearing at Kroger. What did that have on it? It had Rachelle's blood from those 55 stab wounds. Her blood is on his clothing. And what did he do with it? He hid it. He put it in the basement, in the dark basement. This isn't some accident or anything like that. If he didn't mean to do something, why is he covering it up? Why is he trying to hide his clothing? Where are the shorts? 55 stab wounds. What else does this defendant do? There's nobody else that's in this house. Nobody's coming in. Nobody's getting past Rachelle. Nobody's getting past the dog, putting his clothing on, stabbing her, and then cleaning up afterwards and hiding the clothing. That's not happening. It's this defendant's conduct. What else does this defendant do? He cleans up in the bathroom. Her blood is in the bathroom sink. If you didn't mean to do something, why are you hiding your clothing? Why are you cleaning up afterwards to make it look like it didn't happen there? Why do that? It is purposeful conduct when you stab somebody 55 times. The head, the chest, the arms, the hands. What's the phrase, death by 1,000 cuts? This defendant sure tried. 55 is a lot, ladies and gentlemen. And Rachelle's screams were so loud. 74 34-year-old bank robber that was next door on her front porch heard Rachelle screaming for her life. Obviously, you guys are fact finders and truth seekers. You heard her testimony from this witness stand. Is it reasonable to believe that that blood-curdling scream that she heard is coming from Michaela's mother? Your reason and common sense tells you that, ladies and gentlemen. This isn't some accidental conduct by this defendant. He wanted Rachelle to die. What else did this defendant do? In his clothing, the gray vest, the gray shirt, washed up in blood. And again, the 12 of you are the fact finders and truth seekers in this case. And I'm not going to put any photos up there on the screen, but look at those stab wounds to Rachelle. Look at the cutting in the clothing of not only Rachelle, but of this defendant. Doesn't it kind of look like that knife that we just had up there, that Swiss Army knife? Doesn't it kind of look like that knife? Where did we find that knife? It wasn't laying there in the middle of the crime scene. You put it in Rachelle's purse, her book bag. If this was some accidental conduct or he didn't mean to do something, why go through all these measures, these methods, to try and hide what it is that happened, to hide the clothing, to wash up the blood, to hide the murder weapon? Why take the time to take the bloody clothing downstairs in the dark? Why? He wanted Rachelle to die on October 11th. Whatever it is that happened, was it something over, I think it was Brian Short, I believe you heard from him on Tuesday morning. He told you, I'm explaining to Rachelle what it is that's going on, what it is that happened, why we couldn't work on the gas lines. And Brian Short, from this witness stand right here, he told you, as I'm explaining this to Rachelle, he was looking right at this defendant right here, giving him the look. And you're right, Mr. Wilder is correct. I'm going to tell you, I don't have to prove what the motive is in this case. The 55 stab wounds is pretty darn personal. Something happened. "55 stab wounds. How do you not mean to do it when you have 55 stab wounds? One stab wound, maybe you could say you didn't mean to do it. Probably not, but again, maybe. But 55 to the head, the chest, the abdomen, the arms, the hands. Come on, ladies and gentlemen. That is not reasonable. It's not reasonable at all. Why give CPR? Why give chest compressions? Again, defendant is keeping up the ruse of trying to get people to believe that he's not the one that did it. Hiding the clothing, washing up the blood, putting the murder weapon back in her purse. Detective Katie Johnson told you when I get there, this woman's obviously dead. The intestines are hanging out of her body. She's pale. He's trying to keep up the ruse that he had nothing to do with this. Defendant told you from his mouth, State's Exhibit 250, you'll have a chance to play it back in the jury room. He told his own daughter, the daughter that him and Rachelle have together. This defendant said, I'm responsible for what happened to her. I'm responsible for what happened to her. What happened to her was 55 stab wounds. And that's what he's responsible for, ladies and gentlemen. Ladies and gentlemen, I do want to thank each and every one of you for your time and attention. Mr. Wilder said, I'm going to say some of the same things that he said. I've been paying attention to each and every one of you. As you're seated over there, you've been paying attention, you've been taking notes, you've been listening to the testimony. Thank you for your patience with me through some of my computer issues that I had. 55 times. Each time this defendant stabbed Rachelle, she got closer to her death. As Dr. Updegrove told you through those photographs. Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that State
Okay,
Exhibit
jurors, I'm
number
going to ask you to
66
return to the jury
State
room.
Exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood get in the sink? I told them that there was blood on my face after I was doing CPR, and I told them that I
We're
went
going
to
to
the
take a
sink.
recess at this time.
Look at state number, exhibit number 66. Ask for it back there and see. There's a stick right there. They won't. There's plenty of things they won't bring to you. Ask for it. Right?
You can get there. Okay, now we're
Right.
done. Okay, so
I know you're not commenting.
the court is not going to tolerate. Let me go back on from there.
You're not, listen,
All right,
what
we're
you're
going
not
to
going
move
to
to
do
the
is I'm not
defendant to
going to
the
sit
upstairs
here
remote
and
location to
allow
take a
you
recess.
to.
Thank you.
This is what you did the last time went on. You want to come running down the hall this time? You got something to say?
Okay, it's going to take us about 10 minutes to get situated for the defendant to appear remotely. I do have copies of the final instructions for counsel. We'll share those at this time. And the court will need to read an instruction to the jurors as to why he is not in the room. I'm going to take that straight out of the Ohio Jury Instructions Manual. And once we are ready to go upstairs, we will proceed. But if counsel wants to review that instruction, you're welcome to do so. It's 2 OJI CR 4303, and if there are is any discussion you'd like to have about that prior to me giving it, you're welcome to let me know. Okay, so we can go off the record. Thank you.
Thank you, Judge.
Is that a copy?
Yes. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden. For the record, Mr. Madden has been taken to another location in the building. He is able to view these proceedings remotely and hear what is going on in the courtroom, and we are able to view him as well, but his voice will not be able to come through our system, so we will be able to proceed without further disruption. So I apologize to counsel and to those in the gallery for the disruption, and if there's nothing else from the state, we'll bring in the jurors and proceed.
I believe that's correct, Your Honor. Yes.
Mr. Wilder?
Nothing from the defense, thank you.
Okay, please bring in the jury. Please be seated. Are there any violations of the court's recess instructions that anyone needs to report? Okay. Ladies and gentlemen, the defendant has a right to be in the courtroom at every stage of the trial unless the defendant's conduct is so disruptive that the trial cannot reasonably be conducted with the defendant's continued physical presence. The court has concluded, due to the defendant's conduct, that the trial will proceed in the defendant's absence by remote contemporaneous video as if the defendant were present. You may not consider the defendant's conduct or absence for any purpose, nor are you to consider the court's response to the conduct. The statements the defendant was making to you are not evidence. They were not made under oath or on the witness stand and may not be considered by you for any purpose. You must decide this case solely on the evidence presented. Now, ladies and gentlemen, you have heard the evidence and arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor apply your own idea of what the law should be. The instructions I am about to give you will be lengthy and involved. The nature of the case requires these extensive instructions of law, which will include legal concepts and definitions which may be unfamiliar to you. Please listen carefully. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with an offense. The fact that an indictment was filed may not be considered by you for any purpose. The defendant's plea of not guilty is a denial of all charges and puts in issue all of the essential elements of the offense. The defendant is presumed to be innocent until his guilt has been established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. If after a full and impartial consideration of all the evidence, you are firmly convinced of the truth of the charge, the state has proved its case beyond a reasonable doubt. If you are not firmly convinced of the truth of the charge, you must find the defendant not guilty. What is the evidence? Evidence is all the testimony received from the witness stand and the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It also includes the exhibits admitted into evidence during the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may make but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. By way of example of circumstantial evidence, if the question of a fact in a given case is whether or not Johnny ate the cherry pie, testimony by a witness that he saw Johnny put the pie in his mouth and eat it would be direct evidence of such fact. However, if a witness testifies that he arrived in the kitchen only to see Johnny standing there with the empty pie tin in his hand and cherry pie on his face, that would be circumstantial evidence of the fact that Johnny ate the pie. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated by you as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference from or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts and the weight of the evidence. To weigh the evidence, you must consider the credibility, that is, the believability of the witnesses. You will use the test of truthfulness, which you use in your daily lives. There are several tests of truthfulness, one of which is the bias or interest, if any, of a witness. That is, if a witness has a personal, philosophical, or financial interest in the outcome of a case, that fact can be considered in determining the weight to be given to that witness's testimony. Other tests of truthfulness, which you will consider, include the appearance of each witness upon the stand, his or her manner of testifying, the intelligence of the witness, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which he or she testified, his or her accuracy of memory, frankness or lack of it, together with all the facts and circumstances surrounding the testimony. Apply these tests and assign the weight you deem proper to the testimony of each witness. You are not required to believe the testimony of any witness simply because he or she was under an oath. You may believe or disbelieve all or part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of that issue. Rather, the final test in judging evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness, believed by you, is sufficient to prove any fact. If there are discrepancies in a witness's testimony or between any witness's testimony and the testimony of other witnesses, this does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them differently after the passage of time. You are all certainly aware that two persons who are witnesses to an event may see or hear it differently. In considering a discrepancy in a witness's testimony, you should consider whether that discrepancy concerns an important fact or a trivial one. Should you in the course of your deliberations conclude that any witness has intentionally testified falsely to a material fact, you are free to disregard all of that witness's testimony on the principle that one who testifies falsely as to one material fact may also testify falsely as to other facts. You are not required, however, in all circumstances to consider such a witness unworthy of belief. You may accept as much of the testimony of that witness as you wish to believe to be true and reject only that part which you conclude is false. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based upon such assumption. You must determine whether the assumed facts upon which the expert based his or her opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the expert. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. If you find the state has proved beyond a reasonable doubt all of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings as to the defendant. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings as to the defendant. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to the other counts. The defendant may be found guilty or not guilty of any one or all of the offenses charged. It is not necessary that the defendant take the witness stand in his own defense. The defendant has a constitutional right not to testify, and he must not be prejudiced in any way for exercising that constitutional right. The fact that the defendant did not testify must not be discussed in your deliberations, and it must not be considered for any purpose. Now, under count 1 of the indictment, the defendant is charged with murder. And before you can find the defendant guilty of murder, you must first find, beyond a reasonable doubt, that on or about October the 11th of 2022 in Butler County, Ohio, the defendant purposely caused the death of Rachelle Brewsaugh. Purpose to cause the death of another is an essential element of the crime of murder. A person acts purposely when it is his or her specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Rachelle Brewsaugh. Cause is an essential element of the offense of murder. Cause is an act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. In count 1, the essential elements of the offense of murder are 1, that the defendant did, 2, purposely, 3, cause another's death, specifically that of Rachelle Brewsaugh, and 4, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 2 of the indictment, the defendant is charged with murder. Before you can find the defendant guilty of murder, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant caused the death of Rachelle Brewsaugh as a proximate result of committing the offense known as felonious assault. The court has previously defined the term of causation for you. Now, before you can find the defendant was committing the offense known as felonious assault, you must find beyond a reasonable doubt that the defendant, on or about October the 11th of 2022 in Butler County, Ohio, knowingly caused serious physical harm to Rachelle Brewsaugh or caused or attempted to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances and evidence. You will determine from the facts and circumstances and evidence whether there existed at the time in the mind of the defendant an awareness of the probability that his conduct would result in him causing or attempting to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon or causing serious physical harm to Rachelle Brewsaugh. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. The concept of causation has previously been defined for you. Now, an attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. A deadly weapon is an instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative, either the instrument, device, or thing was designed or specifically adapted for use as a weapon, such as a gun, billy club, or brass knuckles, or it was possessed, carried, or used in this case as a weapon. These are questions of fact for you to decide. Serious physical harm to persons means any of the following: any harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. In count 2, the essential elements of the offense of murder are 1, that the defendant did, 2, cause, 3, another's death, specifically that of Rachelle Brewsaugh, 4, as a proximate result of the defendant's committing, 5, the offense of felonious assault, and 6, in Butler County, Ohio. If you find that the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of murder, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of murder, then you must find the defendant not guilty. Under count 3 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused serious physical harm to Rachelle Brewsaugh. The court previously defined all terms necessary for you to decide count 3. Those definitions apply here as well. In count 3, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause, 4, serious physical harm to Rachelle Brewsaugh, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 3, your verdict must be guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 3, then you must find the defendant not guilty. Under count 4 of the indictment, the defendant is charged with felonious assault. Before you can find the defendant guilty of felonious assault, you must first find beyond a reasonable doubt that on or about October the 11th of 2022 in Butler County, Ohio, the defendant knowingly caused or attempted to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon. The court previously defined all terms necessary for you to decide count 4. Those definitions apply here as well. In count 4, the essential elements of the offense of felonious assault are 1, that the defendant did, 2, knowingly, 3, cause or attempt to cause, 4, physical harm to Rachelle Brewsaugh by means of a deadly weapon, 5, in Butler County, Ohio. If you find the state of Ohio proved beyond a reasonable doubt all of the essential elements of the offense of felonious assault in count 4, your verdict must be guilty. If you find that the state of Ohio failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault in count 4, then you must find the defendant not guilty. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of the guilt or innocence of the defendant and to the determination of any additional findings that may be submitted to you. In the event you find the defendant guilty, the duty of determining punishment is placed by law upon the court. You must not be influenced by any consideration of bias, sympathy, or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence. Make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that the case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication on the court's views on the facts, you are instructed to disregard it. You will be provided with a copy of these instructions. If during your deliberations you are in doubt about a portion of the instructions, you may request clarification. The foreperson must put your question in writing, stating specifically what is requested, and that communication must be delivered to the bailiff. Your initial conduct upon entering the jury room is a matter of importance. It is not wise to express immediately a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest opinions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Now, you have been permitted but not required to take notes during the trial. You will recall that I instructed you prior to distributing the notepads that the decision to take notes was a purely personal one for each juror, based upon individual habit and preference. As I said at the beginning of the trial, note-taking does not make a juror necessarily a more careful auditor of the testimony or a better observer of a witness's demeanor. Obviously, the notes of the individual jurors are not in any way to be considered verbatim records of testimony. It cannot be overemphasized that an individual juror's notes are just memory aids for that particular juror. Now, our alternate jurors, you were selected to serve in the event of any misfortune to a member of the panel. It appears that everyone is well and able to continue, so fortunately your services will not be required anymore at this point, and it will not be necessary for you to serve further. You are not to discuss this case or tell anyone how you would have voted until after this jury has returned its verdict. You will be excused when I leave the bench, and I would ask you to please leave your contact information with Mr. Halcomb in the event that one of the jurors is unable to continue, because you would be called back in and would then need to serve. So again, it is important that you not discuss this case until the jurors have rendered their verdict. On behalf of the public and the parties, I wish to express my appreciation for your services in performing this most important function. Now, the first order of business in the jury room is going to be to select a foreperson, and the court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these materials and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose the status of your deliberations or the nature of your verdict to anyone else. Now, the verdict forms that I am talking about will look like this. There will be 4 of them. Each one has the case caption, and it will say, "We, the jury, being duly impaneled, find the defendant, Toby Madden," and you're instructed to check 1. Not guilty or guilty, and there's 1 for each of the offense. 1 for count 1 murder, 2 for count. The second verdict form is for the second count of murder. The third verdict form is for count 3, felonious assault, and the 4th form for count 4, felonious assault. And you'll see that there are 12 lines. In order to reach a verdict, each of you must sign in ink. After you have reached a verdict and you've signed those forms in ink, you will knock on the door and let Mr. Halcomb know that you have reached a verdict, and then we will return you to the courtroom. Okay, at this time I'd like to invite counsel to sidebar. Okay, please be seated. We're back on the record in State v. Madden, CR 22-121675. Mr. Burris and Mr. Hahn are present on behalf of the state of Ohio, and Mr. Wilder is present on behalf of Mr. Madden. Mr. Madden is appearing remotely at another location in this building, and he is able to hear these proceedings. Okay, so I've been advised that the jury has a verdict. However, some concerns were brought to my attention during the recess that I'd like to address at this time, and I'd like to ask Sergeant Owens to please take the witness stand. Okay, Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And Sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state?
No, Your Honor, thank you.
Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the Sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right, so I understand the jury has reached a verdict, and we are waiting on the state's representative.
He should be here momentarily.
Okay, well, we'll go off the record for just a moment. Jurors in at this time? Okay, please be seated. Okay, ladies and gentlemen, I understand that you have reached a verdict in this case. Is that correct?
Yes.
Okay, and who is our foreperson? Okay, would you please return the verdict forms to Mr. Halcomb? Verdict form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. And the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
No, thank you.
Okay. Okay, ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your patience with us during some of the breaks that we had to have and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is the finest in the world, and it is so very important in preserving the property and liberty and the rights of citizens that you are willing to agree to serve as jurors in this case. By your being here and participating, you are helping to guarantee the continued existence of law and social order in our society. So you have my thanks. And I'd also like to thank the attorneys in this matter for their professionalism. I have had you under an order that you could not speak about this case. Now that you have rendered your verdict, you are permitted, I will release you from that order. You are permitted to speak with anyone that you wish to about this case. You are not required to speak to anyone, but that will be your choice alone. In addition, I gave you restrictions about looking at things and investigating things. All of the orders that I gave you you're now released from those. And again, I appreciate your service very much. So you are discharged with the thanks of the court. I would ask that you return briefly to the jury room. Thank you. be seated, and the jurors have been excused from the courtroom. Our next order of business is to take up the repeat violent offender specification. The court has reviewed State Exhibit 251. Is there anything else that the state of Ohio would like to put on the record with regards to that?
I think I put on the record, I did file notice of intent to use. Certified conviction is proof of the prior conviction. That was filed on January 11th, 2024. It is a felonious assault conviction, aggravated assault, which I don't think that part counts. It is the felonious assault is the count 4. It's in CR 88030207, so I would ask the court to find Toby Madden to be a repeat violent offender.
Any argument on that, Mr. Weiler?
No, Judge. Thank
Okay.
you.
All right. The court has carefully reviewed the exhibit and is going to find Mr. Madden guilty of that specification, and will find that he is a repeat violent offender. Okay. The next thing that I need to ask is everyone to prepare to go forward with sentencing this afternoon.
Yes, Your Honor, thank you.
Yes, Judge.
Okay. All right. Before we proceed to that, the conviction will require that Mr. Madden enroll as a violent offender pursuant to Ohio Revised Code 2903.41. And, of course, we can continue that hearing. The basis for rebutting that, the presumption that the court placed him on that registration would be that he is not the principal offender. I haven't heard any testimony that would suggest that that would be necessary. Mr. Wilder, do you oppose going forward today?
I would agree with that. No opposition to going forward. Thank you.
All right. So I'm going to give Mr. Madden some advisements, and there will be a form that I'll ask the deputies to have him sign, and so that he can have a copy of it when we've concluded our hearing. Sir, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code Section 2903.41. If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after release from jail. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing or occupying in a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide to the sheriff certain information, including your full name and alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you were initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. And so that is the form, and I will go ahead and sign that at this point, and we will have Mr. Madden sign that when we have completed our hearing. Anything else on that issue from the state?
I don't believe so, Your Honor. Thank you.
Anything on behalf of the defendant?
Nothing, Judge. Thank you.
Okay. All right, then let's go ahead and discuss sentencing. First, I'd like to ask if the state of Ohio, if you believe any of these offenses are allied offenses of similar import.
The answer would be yes, Your Honor. I will, since the jury has found Mr. Madden guilty on all 4 counts, and I believe the court found him to be a repeat violent offender, which I think would be on all 4 counts, I would agree that counts 2, 3, and 4 would be allied offenses to count 1, and I'd ask that 2, 3, and 4 be merged into count 1.
Do you wish to be heard on that issue, Mr. Wilder?
No, I would agree with that merger.
All right, then the court will merge counts 2, 3, and 4 into count 1, and we will proceed with sentencing on count 1. Okay, is there any mitigation that you'd like to offer on behalf of your client at this time, Mr. Wilder?
Judge, anticipating Mr. Madden will file an appeal in this case, which I will do for him. I have nothing further to say. I would note that I believe the RVO specification and any sentence on that would be discretionary as opposed to mandatory, but nothing further.
All right, at this time, I would ask our information technology specialist to please unmute the video feed. And Mr. Madden, if there's anything that you'd like to say on your own behalf, you're welcome to say it at this time.
Well, I would like to say something, Your Honor. I found it. I'm truly sorry to my family, to Michaela, Sherry, Ginger, Morgan, Megan, Maya, not those Megan, Maya, Morgan, and Jim, Alex, and Brandon, John, and all of her friends, Paulita, Christy, and Dawn, and I told Mr. Wilder that I'm responsible, that I committed this offense, and I told him how, and I told him what happened. I went into detail, and I told him what happened, and for some reason he chose to allow the state to perform an act of their and state that I tried to hide everything that I'd done, and as if I didn't do it. I never mentioned that one time that I didn't do it. I told these officers, these deputies, that I'd done it, and he knows that too. And for whatever reason, the mistake decided, he decided not to put up the exhibit number that I requested. He never pulled up the phone records. He never went and asked for the. Have you ever seen a murder trial where there's never been the interview produced to be seen? Not even on TV and A&B movies, but I understand why. He had an agenda, and but at this point in time,
I'm objecting to that.
I accept the court's decision.
Sustained.
But it's if there's anyone out there that wants to get to the bottom of it, and you're able to come and really see, you see that that there's some discrepancies here that aren't matching up, and there's so many that I can put you on the trail to, and the kibbles and bits are laying right on the floor. But when you're poor, this man I never saw for almost 4 months.
All right, Mr. Madden, I'm going to interrupt you. Okay, let's go ahead and mute it.
2 days before it was time to go to trial discussion, now he says, hey, listen, I'm going to be able to prove through logs that I showed up.
Okay.
You don't have to mute it. You don't have to mute it. I'll stop going into detail, but I'll tell you this.
I'm interested in hearing anything that you want to tell me as to why I should give you, how I should sentence you.
Well, I just want you to know this. To my family, you know, all the years. If it did please you to know that somebody is suffering, I don't presume to know the pain that you're going through. I don't presume to know the pain that you're going through. But and I don't understand it. But I can tell you, you don't know the pain that I'm going through, knowing that I'm the one that caused this tragedy. And if there's any solace, if there's any silver lining in knowing that when I go to bed, it's on my mind. When I wake up in the morning, it's on my mind.
When I think about SeaWorld in San Diego, I think about walking on the beach in Florida, the chalet in Gatlinburg in February. I think about all the years, all the meals that we've had together, the Christmases, the Thanksgivings, the summers. These feelings, these emotions are
All right. It appears the audio has been turned off at this time. Any objections to that, Mr. Wilder?
To the audio being
Yes,
turned
sir.
off? No objection to that. I would, if I may.
You
because
may.
it's televised.
Yes, sir.
Without getting into specifics, obviously honoring the attorney-client privilege that I've held with Mr. Madden for 9 months, I can say that the specifics of the before, during, and after were never brought to my attention.
All
Thank
right.
you.
Thank you. Okay, so at this time, if there are any victims' representatives that wish to address the court will hear those statements.
I believe Michaela Mann is the first one that's going to address the court. Would you like her at the podium? Would you like her at the witness stand?
The podium's fine, since it's here. What would you like to tell me, ma'am?
I would just like to speak about my mom. That's good.
Sure.
Sorry, I'm a little shaky.
Take your time.
Okay.
Closer.
You're fine.
Ladies and gentlemen, I'm Michaela Madden. I'm Rachelle Brewsaugh's daughter and our only child. I wanted to make this statement because I want you to know more about my mother, Rachelle Brewsaugh. She meant so much to our family and friends. Her death has created a huge hole in our lives from which we will never recover. Rachelle, my mother, was the youngest of 4 children. She was the baby of the family. But she wasn't just a sister and a daughter. She was also an aunt, a neighbor, a friend, a member of the community, and perhaps her most important role, a mother and grandmother. Sorry. As an only child, I had the benefits of all her love and attention. She always sought to have that everything I needed. She taught me to be respectful and to be well-mannered, to work hard and help others. She dedicated her life to serve. She was a nurse, and I'm following in her footsteps and hoping to become a nurse. I mentioned that my mom was also a grandmother. I'll never forget how thrilled she was to have a granddaughter. My mom relished on every moment that she had with my daughter, Layla. After I had Layla, I noticed a change in her. My mom wanted to leave her life with Toby Madden in the past. She was focused on and excited for a better life filled with love for me and her granddaughter, Layla. This has been unimaginable for me and my family. But how can I tell you who my mom was? It's impossible to express in words who my mom was and the impact this had on our family. I will miss the big things. She loved animals, especially dogs, butterflies, and dolphins. She went out of her way to help everyone. She had no enemies. She was hilarious and smart. She had an infectious laugh. And she and I were so very close. We talked about everything. She was my best friend. The one thing that got in the way and we disagreed with was Toby Madden. He was a man that my mother set out to change. He was the man who came in and out of our lives because all he did was take. All he did was take. He was never a loving partner for her, and he was not a good dad. I mentioned that my mom always focused on others. She took care of him through thick and thin. But Toby's only interest was to put us down. All of her accomplishments. But I have made a better impact on my life than he ever will. People ask me if I'm better or if time has healed me. I will never get over losing my mother. Her life should have never ended so tragically. My mom was a healthy 50-year-old woman. She was full of life. She was ready to move on to the next chapter in her life from Toby. A chapter full of things to do, places to go, and happiness. My life will go on. I will raise my daughter, and Toby Madden will fade into the past for me and my family. There are going to be days that Toby will wonder about us, but he will never know what is going on in our lives, and he will never get the chance to see his granddaughter grow old. Even though Toby Madden ended my sweet mother's life, she will always be with me. He's not going to end our lives, but his selfish, disgusting act of taking my mother's life will end his life as well. I know she's in heaven with God and her mother and father and sister and brother who have also passed, but I would give anything to talk to her one more time, to see her be silly and laugh with my daughter, Layla. But I know I will never, because Toby took that away from us. And I just want to say thank you to the court, thank you to the judge, thank you to the police officers, detectives, my family and friends for everything that you've done.
I'm very sorry for your loss, ma'am.
Thank you.
Is there anyone else that wishes to address the court, Mr. Burrs? Ma'am, if you could tell me your name and your relationship to the victim, please.
Hi, my name is Ginger Halcomb. I'm niece of Rachelle Brewsaugh. Our rules have changed forever, and when I say our, I mean my Aunt Rachelle, our family, and her best friends. I know they say when you're a good Christian that you'll forgive what he did one day. But forgiveness or not, our family asks that Toby Madden gets life in prison without parole for brutally murdering our aunt. She has taken so much from us. He's a repetitive violent offender that has a track record to prove at the age of 52 that he has no chance of rehabilitation. Our local community itself is not safe with him unless he is behind bars the remainder of his life. Knowing that he doesn't have a chance to victimize our family anymore is the only way that we'll get time to process everything and start to heal. Over the course of 26 years, our family has been victims of so much violence because of his erratic, violent behavior. There are too many to even mention and not enough time to talk about. We have all been emotionally drained, having to wait 2 selfish years due to the delay tactics. The continual delays feel like it was his last selfish act to resort to torment our family further. Waking up every day to realize that your aunt is gone forever, that's not only like a second mother, but a best friend, is torture in itself. The nightmares continue to invade our lives as we try to hold each other together. We worry about what happens if he would get out. Do we have to relocate, change our names, or do we ever have to face this monster ever again? For my aunt to lose her life alone due to this vicious predator, life in prison is an easy choice to be given. At the end of the day, he still will have his life, even if it's behind bars. All I can ask of you is to please choose life in prison and to give him the maximum sentence of being a violent, repetitive offender so that our family is safe. Our family, the Halcomb family, the Brewsaugh family, we want to thank everyone that's been a part of this case from the beginning to the end to the jury. That's all I have to say.
Thank you for your comments, ma'am. I do need to let you know that this statute does not give me the authority to impose a sentence of life without parole, but I will consider your comments when I make the decisions that I have the authority to make. And I'm sorry for your loss.
Thank you very much.
Thank you. Anything else from the state of Ohio, Mr. Burrs or Mr. Hahn?
The only other thing I would like to say, I would like to thank the City of Hamilton Police Department for their work on this case. I know I think there's maybe 3 officers that testified, but there are many more that were part of this case, and justice would not have been served today without all their efforts. So thank you.
Very well. All Right. Well, the court has considered the purposes and principles of sentencing in Revised Code Section 292911 and the seriousness and recidivism factors in Revised Code Section 292912, as well as the penalties that are statutory penalties that are associated with the offense and the specification. The court is also considering the record and the charge and the statements made at this hearing, and the court on count 1 is going to impose the mandatory sentence of an indefinite mandatory minimum term of 15 years in prison and a maximum term of life imprisonment in the Ohio Department of Rehabilitation and Correction. As to the repeat violent offender specification, the court is going to impose 10 years, and it will be consecutive to this sentence. The court is imposing the maximum of 10 years because this offense was quite frankly so gruesome, and the court finds that the defendant is a danger to the public, and the court relies on the Exhibit 251 and the offenses that Mr. Madden has previously been convicted of in support of those findings. The court is going to run this sentence in this case consecutive to the sentence in case number CR 22101423, and the court is running it consecutive because it believes that consecutive sentences are necessary to protect the public from future crime and to punish the offender. The court further finds that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger that he poses to the public. And the court finds that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. The court is also going to impose court costs as a part of the sentence, and the court will award 316 days of jail time credit. Are there any other findings that the state wishes for the court to make at this time?
So it's 15 years to life. The RVO is consecutive. I think that's by law, isn't it? Any sentence on the RVO is consecutive by law. And what was Judge Stevens' case number?
That is a CR 22101423.
I don't believe there's anything else, Your Honor.
Okay. Anything on behalf of the defendant?
Sure. Judge, I don't know if this is required or not. Should there be any advisement at all about PRC at all, given the sentence? May not. I was just making sure we're clear before we left.
My understanding that it does not, because of the indefinite nature of this sentence, the defendant would be subject to parole rather than post-release control. Does the state have any objection to the court's findings? Okay.
Nothing further than.
And then the final thing that I would indicate that this defendant does have a right of appeal, and he has 30 days from the date that the conviction entry is filed to file that notice of appeal.
I will file that for him, understanding that he will have a new attorney on the appeal.
Yes, sir.
Thank
All right.
you, Judge.
Well, again, I thank the counsel for their professionalism, and at this time we will recess on this matter. Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back